Hello, my dear friends, and a very warm welcome. Today, we are about to discuss a very important article under the Constitutional Law of India, and this article happens to be very important as far as the administration of criminal law is concerned in our country. And this article is number 20, and it talks about the protection of certain rights in case of conviction of offences. Now, what we have to understand is that basically Article 20 has been divided into three clauses, and these three clauses are going to also be our focus areas for this video session. If you look at the slide, Article 20, Clause 1 talks about ex post facto laws. Article 20, Clause 2 talks about double jeopardy, and Article 20, Clause 3 talks about the concept of self-incrimination. Hence, this breakup of Article 20 clause by clause is going to remain our focus area for this session. Let's move further. What is the nature of Article 20? Now, as I mentioned earlier, and the very title of the article tells us that it is protecting certain rights in case an individual is convicted for an offense. Now, what is the meaning of conviction? Conviction basically means that when a court of competent jurisdiction declares you guilty of a criminal offense. So, a very natural corollary to this statement that I have just made is that this article only applies to criminal proceedings and it does not apply to civil proceedings. Let's take a look at the slide. We've just discussed the meaning of conviction, and it is basically safeguarding not only individuals but also corporations in a scenario when they get accused of a criminal offense. What is the most outstanding feature about this article? Students, you must always remember that this article cannot be suspended even during the time of emergency. So, always remember that there are very few articles which cannot be suspended even when an emergency has been imposed in our country, and Article 20 is one such article. What else is Article 20 doing? Article 20 is performing a really important function, and that function happens to be placing a limitation on the legislative powers. That is, it curtails the state legislature as well as the union legislature from enacting certain laws which will interfere with the rights of an individual who has been convicted of a criminal offense. Let's move further. Now, we are going to start by discussing the first clause of this article. Article 20, Clause 1 talks about no ex post facto laws. Now, if you look at the first point on the slide, we'll understand that ex post facto law is basically a Latin expression and it simply means after the fact. So, what does it mean in layman language? That you cannot make a person criminally accountable for an act that he or she has done at a time when there was no law declaring that act illegal. Now, the protection that this article is according is three-pronged in nature. That is, it is giving a three-aspect protection. First of all, it puts a stop on the parliament or state legislature from enacting such a law which will declare an act which was legal at a certain time and later on it declares it illegal. So converting an act which was legal to an illegal act at a later time has been prohibited by virtue of this article. The next thing is less punishment. If less punishment gets replaced by more punishment, say for example when a person was sent to imprisonment for, say, committing the offense of theft, and if we know that the maximum imprisonment that can be given, let's say, is 2 years, but after the person has been awarded his sentence by the court and while he or she is in prison, the punishment is enhanced to, say for example, 5 years. So at that time it will not apply to that individual this sentence of 5 years, this increased imprisonment of 5 years, who has already been tried under the law which only allowed 2 years of imprisonment. Similarly, when I spoke about making a legal act illegal later on. It means that, say for example, the last week you were driving on the road, the speed limit was 60 for your car and you were driving at a speed of 50. Now, if next week a law is passed which says exceeding 40 is going to amount to overspeeding and you're sent a challan at home, so that will be giving a retrospective effect to this situation and you are going to be punished for an act which, while you were doing that act, you were under the impression is completely legal. Then the third thing is, if rules of evidence are changed, that is, if you are going to be made culpable, liable or responsible for an offense even by giving very less evidence, then that will also come under the category of ex post facto law. So constitution is not giving any kind of validity to ex post facto laws, and the very objective behind this article is to ensure that no such individual gets punished for doing an act which that person in all innocence believed to be legal, and later on you subject that individual to punishment. So that will be completely against the idea of natural justice. Also, what we have to remember is that when a human being is completely aware about what act amounts to an illegal act or what act amounts to a legal act, so we can exercise a very clear choice whether we want to do that act or not. And when we have clear guidelines as to what acts amount to offenses, we are able to make a free choice. But if you do an act under the impression that it's legal and later on it is not only made an illegal act but you're also punished for it retrospectively, that will go against the mandate of the Constitution. Moving further, the next clause of Article 20 talks about the concept of double jeopardy. Now let us understand the title itself. Well, if you simply look at the word jeopardy, it means harm, loss or danger. And basically if you now read it together, double jeopardy, it means double harm, double loss and double danger. So what our constitution is prohibiting is that you will not punish an individual twice for the same offense. So it is giving you a two-pronged protection. You are not only being saved from multiple proceedings but also multiple punishments for the same offense. Now, we have borrowed this concept, as the slide tells us, from the American Constitution, and it directly flows from the natural justice concept. Because if you have done one wrong and if you have received an appropriate punishment for it, then you should not be re-punished for the same act. And that is the most fundamental idea behind the concept of natural justice. Then, this maxim on the slide, that is autrefois convict, it means that if a person has been put to trial and he has either been acquitted or convicted once, then he should not be put to trial again. And finally, the last point on the slide tells us the ultimate objective behind this subclause of Article 20, that it is saving you from multiple proceedings and punishments. So this is the fundamental idea behind this article. And let me discuss an exception over here. When we are dealing in service matters or we are dealing in the implementation of service rules, departmental rules, what we have to understand is that a departmental inquiry does not come within the definition of judicial proceedings or a judicial trial. So say for example, a government servant has faced departmental inquiry and say for example was subsequently suspended at the end of the inquiry, and later on a case was also initiated against that individual in a court of law. So later on that individual is not going to be able to take the plea that he has already faced trial at the department level. So departmental proceedings and a judicial trial can go hand in hand, and they will not defeat the idea of double jeopardy as has been mentioned under Article 20 clause 2. The last clause of Article 3 talks about self-incrimination. Now In layman terms, self-incrimination simply means exposing yourself by making a statement. But legally speaking, to incriminate yourself would mean to make yourself accountable or to make yourself guilty or responsible for an act. Now, when you're accused of a crime, you have two options. You can either make a choice to speak to the police authorities or any other authority responsible in the administration of justice, or you can choose to remain silent, and nobody can interfere with your choice to remain silent. So the last point on the slide will tell us that no person accused of an offence shall be compelled to be a witness against himself. That is the fundamental ideology behind this clause of Article 20. If you look at the maxim mentioned on this slide, the simple meaning is that no man is bound to accuse himself. That means no one can force you, nobody can compel you to be a witness against yourself. Now, when I use the word compel, I am mostly referring to the concept of starving an individual, beating up an individual, torturing or harassing an individual in order to get a statement out of that person. That comes within the definition of forced or compel. So force and compel directly flow from the word duress. Why do we follow this clause very seriously? Because the very ideology of the Indian Penal Code is based on the concept where the accused is innocent until proven guilty. So the burden of proving the guilt of an individual is always on the other party, that is on the prosecution. And if the prosecution fails to do that, an individual is always going to be given the burden of proof. Then what about the status of confessions? Now, if you look at the scenario in India, lots of confessions are made in police custody, and their admissibility as evidence, or if you talk about their credibility as evidence, that is highly questionable. So what has been done to ensure that confessions are not only genuine but they are voluntary? So now a magistrate can only record in the presence of police the confession of an individual in order to ensure that it was given voluntarily and without any kind of compulsion or duress. Now, what is the nature of protection that is accorded under Article 20, Clause 3? The nature of protection that is being accorded is, first of all, you cannot be compelled to be a witness, and you cannot be compelled to give an evidence against yourself. So first of all, no one can compel you to be a witness in your own case, and the second thing is that no one can ask you to give evidence. Now, evidence can be of three types. Evidence can be documentary, it can be oral, or it can be testimonial. Now, when I say be a witness against yourself, whether it's oral evidence like I discussed, documentary or testimonial, if it is exclusively based on an individual's personal knowledge, only then he or she cannot be forced to furnish that evidence. But if you are asked to give a specimen of your handwriting or signature or thumb impression, or expose a body part, give your blood sample, hair sample, DNA sample, or participate in an identification parade, in that case that will come under the category of furnishing evidence, and that will not come in the category of being a witness against yourself. So there is a huge difference or demarcation in furnishing evidence and being a witness against yourself. Being a witness against yourself is divulging information which is completely personal in nature, and it can be done by producing oral, documentary or testimonial evidence. Now, what are the exceptions to Article 23 that I've just discussed under the category of furnishing evidence? And finally, we are going to discuss Selvi versus State of Karnataka 2010 case. This is a landmark judgment, and it involves the territory of two articles. Article 21, which talks about within its ambit right to privacy, And if you want to understand this article better, please go and watch the video that discusses Article 21 exclusively. And another territory this case specifically talks about is Article 20, Clause 3, that is self-incrimination. In this case, it was laid down by the Honorable Supreme Court that tests like brain mapping, polygraph test, narcoanalysis tests, they invade an individual's mental privacy, and they induce a state of mind where a person is forced to divulge statements or facts which he or she normally would not. So there is a direct interference with the person's mental privacy which comes within the purview of Article 21, and it's in direct contradiction with the safeguards given under Article 20, Clause 3. Hence, all these will directly conflict with the idea of self-incrimination. So with this, friends, we have discussed the various rights and safeguards that are available to an individual who is facing a criminal trial, and how the courts in India and the constitution in India have ensured that they are not denied the basic principles of natural justice, and they face a free and fair trial where they're given an equal opportunity to defend themselves. With this, we've come to an end of this video session. Please keep us updated with your feedback. Thank you very much.